Assalamualaikum everyone. So today our group will present the next question which related to the next chapter, which is formulation and verification of accounting theory under positive accounting theory. Our team members consist of 5 members, which is Fakira, Liana, and me, Darisha, Nur Farah Hidayah, and Nur Ain Farhana. The first presenter will be me, Darisha Hadira. The next one, Liana binti Masruhin. After Liana, we have Nur Fakira Isha. And the next one is Nur Ain Farhana. And the last presenter will be Nur Farah Hidayah. But before that, the question asked us regarding to review the business newspaper articles, Bursa Malaysia and the Securities Commission websites, and choose the news about a Malaysian company that has a management shareholder dispute. And we have to present which describe the company and the nature of the dispute, as well as how the agency theory explains and solve the dispute. So this is the article of choice. This is the article of our choice, which is regarding the Menang Corp shareholders and the company's chairman. And this dispute is regarding the Menang Corp shareholders that initiate court action against against the companies and the company's chairman. So if you want to read further, you can click on the link stated there. So the next one is first and foremost, we want to explain regarding the company's background. So Menang Corp Berhad is actually incorporated on 9 July 1964, and it is listed on the main board of Bursa Malaysia Securities Berhad. And the company is principally engaged in investment holding, letting out of properties, as well as the provision of management service. Next, the nature of dispute. So, on November 11, Menang Corp announced that Liu and Toh, which is Liu Suk Pin and Toh Mei Fu, would be proposing the appointment of each other as directors of the company for shareholders consideration at the company's annual general meeting that held on December 30. But plus, they also wanted to remove Dr. Christopher Shun Kang Lang as director. Unfortunately, its filing on Bursa Malaysia on December 30 revealed that the resolutions to appoint them as new directors in the board, as well as to remove Dr. Christopher as director, were withdrawn by the chairman. But no explanation was given to them as to why the withdrawal of the resolutions happened. So, on January 2018, two of them, which is Toh Mei Fu and Liu Suk Pin, have commenced a court action against the companies and its chairman, Raja Shahruddin Rashid. And the group which announced this in a filing to Bursa Malaysia did not state why the action was initiated by the two shareholders. That it means that they doesn't know why the two shareholders commenced the court action against them. And for your information, the Dr. Christopher Shun Kang Lang is the brother-in-law of the chairman, which is Raja Shahruddin Rashid. So the next one is the dispute based on agency theory. So I would like to call Liana binti Masruhin to explain further regarding this.
Okay, thank you, Darisha. Now we move to the dispute based on agency theory. Okay, before we move to the case analysis of the company, I will explain about what is the agency theory and agency relationship. Agency theory is a principle that is used to explain and resolve issues in the relationship between the business principal and their agents. Agency theory is also often referred to as the agency dilemma or the agency problem. So most commonly, the relationship is the one between the shareholder as the principal and a manager as an agent. The agents basically doing on the work for and behalf for the principals. So because the agent makes numerous financial decisions that influence the principal, there may be a conflict of opinion as well as the differences in priorities and interests. Next, agency theory also assumes that the interests of a principal and an agent are not always in alignment. Agency theory highlighted the arises of information asymmetries that create much uncertainty. So there is a gap between the principals and the agents, and not all information that managers know, shareholder will get it. So basically, the shareholder receive the information only from what manager have told them. Next, agency relationship. The agency relationship is a central focus of agency theory. So as I have mentioned earlier, the relationship is between the business principals and their agents. The agent is obligated to act in the best interest of the principal because the agent's action will create legal obligation for the principal. So the agency relationship allows the agent to work on behalf of the principal as if the principal was present and acting alone. So what is the agent in the business? Basically, agent is represent the principals in day-to-day transaction. Agents are using resources of principals, hence any losses will be borne by principal. And lastly, principal delegate decision-making authority to the agent. Let's go for the detail. Agency theory defined by Jensen and Macleay in 1976 that state a contract under which one or more principal engage another person, the agent, to perform some service on their behalf, which involve delegating some decision-making authority to the agent. The agency theory key assumption about of self-interest and wealth maximization. So there are a thing about the agency relationship is that both of these parties are self-interested. That means they are going to do whatever suit them best. The things about the relationship is that the fiduciary, the agent doesn't always follow what's in the principal best interest. And this makes a lot of sense because as I just said earlier, we are assuming that everybody is actually self-interested. Okay, before we go to the case analysis of the company, I will give some example of relationship to identify whether they have uh, the existence of agency relationship. So the first relationship is between the shareholder and the manager. So this is an agency relationship as the manager act on behalf of the shareholder. The next relationship is between the teacher and the student. So there are no agency relationship as there is no agent to work on behalf of the principal. Next, how about a dad and a baby? So this is an agency relationship as dad is agent as he act in the best interest of the baby. Next, the relationship between the boss and the worker. So this is also an agency relationship. This one is most likely like same with the shareholder and the manager. And then the relationship between the criminal and the police. So this is not agency relationship. How about if there is corruption between of them? So this is agency relationship as the police work to benefit the criminal. Next, let's move to the case analysis. So in most accounting courses, we usually think that of this between the shareholder, the principal and the manager agents. So in this case, the principal is two of Menang Corporate shareholder as a principal and the agents is the chairman, Raja Sharuddin Rashid. Next, there are existence of information asymmetry as there are no information given to the shareholder who were Leo and To regarding to the withdrawal of resolution made during the AGM to appoint them as a new director and to remove Dr. Christopher Shankong Leng as director. So the information asymmetry made the risk exist because of the uncertainty of the information as Liu and To only knew about the matter from Bursa Malaysia. Next, so based in the article, We also can assume that the chairman, Raja Shahrudin Rashid, did not remove Dr. Christopher Shan Kong Lem because Shan is brother-in-law of Raja Shahrudin. So this is related with the self-interest maximization based on the agency theoretical assumption, as the chairman only think about his own interests. So next, I will pass to the next presenter to explain more detail about the agency problem and the case analysis.
Thank you, Liana, for the explanation. I will proceed to agency problem. What is the agency problem? Agency problem is a conflict of interest inherent in any relationship where one party is expected to act in another's best interest. In corporate finance, an agency problem usually refers to a conflict of interest between a company's management and the company's stockholder. The manager, acting as the agent for the shareholders or principal, is supposed to make decisions that will maximize shareholder wealth, even though it is the manager best interest to maximize their own wealth. The agency problem does not exist without a relationship between a principal and an agent, as mentioned earlier by Liana. In this situation, the Menang Corporation performs a task on behalf of the two shareholders. The agency problem arises in this case due to an issue with incentive and the presence of discretion in task completion. The plaintiff may be motivated to act in a manner that is not favorable for the Menang Corporation if the plaintiff are presented with an incentive to act in this way. Agency problem arise during a relationship between a principal and an agent. Agents are commonly engaged by principals due to different skill level, different employment position, or restriction on time and access. Next slide. Okay, for the case analysis of agency problem that we can take from Menang Corporation based on the statement provided in the slide, two of Menang Corporation's perhaps shareholders have commenced a court action against the company and its chairman Raja Shahrudin Rashid. So the issue of this case is whether the company had the power, express or implied, to suspend the plaintiff as director. From this case, we can apply the agency problem, whereas there are conflict of interest between the shareholders, who are the principal and plaintiff, and company or the agent in this case. Then, for the decision of this case, the court decided that the company did not have the power, express or implied, to suspend the plaintiff as directors. This is because the court take note that there is no express power or to suspend a director either in the Companies Act 2016 or in the company constitution. Therefore, the court must consider whether the power to suspend can be applied. The second reason for the decision is the court decided that the Interpretation Act would not assist in interpreting the company constitution. The Interpretation Act applies only to written law. The third reason is Section 211 of the Company Act 2016 does not exist. The company's interpretation on the power to suspend Section 211 also set out the board's power to manage the business and affairs of the company. The wording of Section 211 cannot be stretched to include the power to suspend. Next. I will proceed to the agency cost. As we know, agency problem will lead to agency cost. So what is the agency cost? Agency costs are a type of internal costs that a principal may incur as a result of the agency problem. They include the cost of any inefficiencies that may arise from employing an agent to take on a task, along with the costs associated with managing the principal-agent relationship and resolving different priorities. While it is not possible to eliminate the agency problem, principal can take steps to minimize the risk of agency costs. Agency costs can occur when the interests of the executive management of a corporation conflict with its shareholder. Shareholder may want management to run the company in a certain manner which increases shareholder value. based on the slide, there are three boxes provided. So there are three types of agency costs, which are monitoring costs, bonding costs, and residual loss. Monitoring costs means cost of monitoring agents' behavior, such as costs in auditing financial statement. Secondly, bonding costs means costs involved in agents bonding their behavior to expectation of principles, such as in preparing financial statement. Lastly, residual loss is the cost that is too costly to remove all opportunistic behaviors, such as reduction in wealth caused by the agent's non-optimal behavior. Next slide. Okay, for the case analysis for agents cost in Menang Corporation, the short statement that I took from the news provided in the slide, in 2019, Toh won the dismissal suit against the company in the industrial court. The court had ruled in his favor, saying that the dismissal was in breach of the rules of natural justice and ordered the company to pay Toh 278,400 ringgit as compensation. Okay, from this statement, clearly we can see that the type of agency cost involved is residual loss. This is because the company has to pay the compensation caused by the agent's non-optimal behavior, and the second reason is the compensation cost attributed to the remaining divergence of interest between Toh and the company, which is Menang Corporation. So that's all from me. I will pass to Nur Ain Farhana.
Now, let us see on how to solve the dispute based on the agency theory. Next. As we can see in the slide, there are 4 solutions of shareholders on how to dispute a problem. Next. For the first solution of shareholder dispute, there is we must check the shareholders agreement and the article. It is because it is very helpful in working out on how the company is to be run and what powers and limits on decision-making ability each shareholder will have. So, an agreed procedure for forcing a shareholder to sell their shares at a sell valuation in certain circumstances, such as a shareholder having their service contract terminate or leaving the company for any other reasons. Besides that, the shareholder agreement or article should include several provision that can assist with resolving any dispute, which can save a great deal of time, money, and also aggravation. And this can highlight the potential difficulties at an early stage. And it is also essential to review shareholder agreement and articles to prevent the fundamental irregularities. According to the article, Menang indicate that Raja Shahruddin had discovered fundamental irregularities in Resolution 7, 8 and 9. It claimed that Resolution 7 and 9 were introduced by non-members and so did not comply with the terms of the Companies Act 2016. Thus, it also shows us that the statement made by Toh and Liu, who are shareholder under Resolution 7 and 8, did not comply the Section 201 of the Companies Act. Next. Second solution of shareholder dispute is full transparency. It is to reduce the potential influx of agency problems, and it's crucial for both of the principal and the agent to be completely transparent with one another. Decision and transaction that will be implemented must be agreed upon by each party and must be reasonably fair. Once transparency is present, conflict is reduced since there is less confusion in decision making and favor implication that one party is against the other. In the article, the chairman of Menang Corporation Berhad, Raja Shahruddin Rashid, has breached his duties as he withdrew the ordinary resolution 7, 8 and 9 during the annual general meeting of the company. Resolution 7 and 8 were regarding the appointment of To and Liu as directors, while Resolution 7 refer to the removal of Raja Shahruddin's brother-in-law, who is Dr. Christopher Shun Kong Leng as director. The withdrawal of these resolutions are made without the knowledge and consent from the shareholders. So we conclude that there is no full transparency between the principal and the agent. Alright, now I will pass to Farah Hidayah.
Okay, thank you, Ain Farhana. Next, what is the other way to solve the management shareholder dispute? The removal of directors. Shareholders representing at least 5% of the company's voting rights can require the board to call a general meeting of the shareholders to consider a resolution to dismiss a director. To be effective, the resolution must be passed at the meeting by more than 50% of the vote cast. This removal power is enshrined in the Companies Act, though the director has the right of appeal. The Companies Act also contains strict procedural requirements, including time limits. There are two main procedural points that have to be noted. The first one, the member who proposed the dismissal must give the company a special notice about the resolution to remove a director at least 28 days prior to the meeting at which the director may be removed. The director in question also must be given a copy of notice, and he or she will be permitted to attend the meeting and make representation. The second main point is the minutes of the meeting must be kept at the company's register office address along with a copy of the resolution. Based on the article, on 19 January 2021, two shareholders of Menang Corporation, Datuk Lee Chinwa and Nicholas Poon Chi Chiang, had sought to remove the chairman, Raja Shahruddin Rashid, the director, Dr. Christopher Shan Kong Leng, and two independent non-executive directors, Wong Kon Wai and Siva Gurunathan V. Narayanasamy. After 2 weeks, the group has announced on Bursa about the resignation of Raja Shahruddin, Dr. Christopher Shan, and Wong Kon Wai and Siva Gurunathan. Next slide. Okay, other than that, to solve the management shareholder dispute, we are using price protection. What is price protection? Price protection is where the principal will pay a lower salary to the agent to limit agents' potentially opportunistic behavior. For example, some agents will take advantage of principal to advance their own interests by making false promises, misrepresenting intention, reneging on agreement, or changing the term of deal to benefit themselves. Other than that, the principal can bring an action or claim a compensation if the director, which is the agents, take an adverse action or conduct a specific wrongdoing. It is stipulated under Companies Act, the the principal only can claim a compensation or bring an action if the director, which is the agents, conduct a specific wrongdoing such as negligence, defaults, breach of duty, and breach of trust. As we found in the article of Menang Corporation Dispute, the court has ordered the company to pay 278,400 ringgit Malaysia to the director Toh Mefuk as a compensation. Why? This is because the dismissal of the director Toh Mefuk was in breach of the rule of natural justice. Okay, that's all from me about the solution of shareholder dispute. Lastly, for conclusion, I will pass to Darisha Hadira.
So it is obviously that we have come to an end. So for the conclusion of this topic or for this question is that, and for this case, we can see that the relationship between two parties, we can see that agency theory refers to the relationship between two parties in which the agent will represent the principal in day-to-day transaction, and this agency theory attempts to explain and resolve the disputes over the particular priorities which is between the principals and their agents, and which in this case regarding the menangkap shareholders and the companies and the chairman. So agency theory also addressed that disputes may arise in two areas which are different in goals and different in risk aversion. As we can see in this case, the disputes arise is because difference in goals, which is the chairman wanted to remain his brother-in-law to remain as the director, while the both of the shareholders want to appointed them as the director of the company. So that's all from us. Thank you.